You gotta mute this thing and then we'll get going. All right. Let's be on the record in two cases, those being 2016 CR1009 and 2020 CR147, both captioned State of Kansas versus Daniel Tolefree. Would the parties announce their appearances, please?
May it please the court, Christopher Schneider, Assistant District Attorney, appears on behalf of the state of Kansas in both cases.
May it please the court, Your Honor. Mr. Tolefree appears in person via video and with counsel Phil Crawford.
All right. We are here set down in the 2016 case for a revo and on the 2020 case for a sentencing. Let's go ahead and do the sentencing first because I think the revocation is not going to take us much time. All right. I would note for the record that the parties were last here in court also by Zoom back on January 4th. At that time, the defendant changed his plea from one of not guilty to guilty. I inquired and accepted that plea, ordered a pre-sentence investigation, and set it for sentencing today. I've received that PSI. The critical findings are as follows. The sole count of conviction is one of possession of methamphetamine. That is a severity level 5 non-person drug felony. The defendant's criminal history score was found to be that of E, as in Edward. That would leave him with a presumption of probation and a presumed underlying sentence of 18, 20, or 22 months. If he has to do that time, he'll be eligible for up to 20% good time credit and subject to post-release supervision duration of 12 months. There is a special rule number 9, which is that this crime was committed while the defendant was on probation for a felony. So that really destroys the presumption of probation and leaves him without a presumption. If he's granted probation today, it would be for a period of 12 months to community corrections. I would ask you first, Mr. Schneider, did you have a chance to take a look at the PSI? Any additions, corrections, or challenges to those findings?
Judge, Mr. Campbell and I both examined the PSI and it appears to be accurate.
All right. Mr. Crawford, same question.
I received the PSI. I had a phone conversation and just now showed the relevant parts of the PSI to Mr. Tolefree. He agrees that he has a criminal history E. There are no objections or additions.
All right. Given that, I'm going to adopt the findings of the pre-sentence investigation for today's hearing. Comments on sentencing, Mr. Schneider?
Judge, I would ask the court to follow the plea agreement in this case. Sentence the defendant to the mitigated term in the new case, and grant him probation with the order that he, if he has not already, which I would have thought he might have, get a substance abuse evaluation and follow the recommendations thereof. And then, Judge, I'll go ahead and address the other case as
Okay.
well. I would ask the court to revoke and reinstate, extend his probation to 12 months from today's date, which is when the probation in the new case would expire, to run the two cases consecutive to each other.
All right. Thank you, Mr. Schneider. Mr. Crawford, comments on sentencing?
Case was fairly negotiated between myself and Mr. Campbell. I asked the court to follow the negotiation for the mitigated term, which would be 18 months with a 12-month probation, and reinstate on 16 CR 1009 with an extension of 12 months. He'll get a drug and alcohol evaluation and do everything he's supposed to do. He understands that he is staring at 1.5 years in custody if he doesn't do what he's supposed to do while on probation.
All right.
Court to determine whether he has the finances to pay costs.
All right. Thank you. Mr. Tolefree, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today. For my court reporter, I believe he said, I don't have anything to say. All right, thank you. Mr. Crawford, know any legal reason why I should not now proceed to sentencing?
No, sir.
All right. Well, Mr. Tolefree, I think you're pretty lucky that your attorney is pretty persuasive. Because normally when I set these hearings, when somebody hasn't shown up and where they need to be, I wait 15 minutes and then I issue the bench warrant. Mr. Crawford asked me a number of times, I'm talking to my client, he's almost here, he's almost here, he's almost here. And for some reason, we waited 20, as I counted it, 23 minutes until your arrival. Let me just tell you what would have happened if Mr. Crawford hadn't done that. I would have issued a bench warrant. At that time, the state would feel released from their obligation to live up to their plea agreement since you didn't show up for your sentencing. And they could ask me, since there is no presumption, to have sent you to prison and to violate your probation, send you to prison on that. And by law, those two sentences have to be consecutive. None of that's going to happen today. Mr. Crawford convinced us to stick around and give you the opportunity. Look, I understand that people get held up and all of this. I just need to give you fair warning that you're not getting off on a great foot, where if we come back here in a couple of months and you're not, let's say you didn't get your eval, or you didn't show up for your appointments to get your eval, or you're missing drug treatment because you show up late, and to come in here and we have this argument all again, you'll have the strike that I've already had to sit here and wait for you for a long time on a day that you're supposed to get probation and that you could not, and you still couldn't get yourself where you needed to be on time.
Yeah.
So look, I'm not going to hold this against you. It's going to, you're going to get the deal that was worked out. You're going to get probation today, but I need you to have an understanding of how close you came to screwing this up and going to prison today. And that if you do that with your probation officer, then it's just going to be a matter of time. Okay?
Yes, sir.
All right.
Can I say something?
Sure.
John, I was not trying to be here late. I got a lot of stuff going on. For one, I'm supposed to be in another court at your district right now. That's who was calling my phone. Nick Campbell is taking care of a case of my brother dying, and I'm supposed to be there right now. So I had to let them know that I wasn't gonna make it. I had court, and I'm supposed to be going to a funeral right now too. So that's the only reason why I was late. Sorry about that. But yeah, I will not be late
Well,
again.
look, I mean, there's a couple of things. If they have a court date on your brother's case, I wish you were there. And probably if you had let anybody know, hey, I'm set in 2 different divisions at the same time, and they don't know it, we would have worked around it. I know I would have. I would have moved this for you. But you didn't tell Mr. Crawford that. You didn't tell me that. I don't know about the funeral. I wish you hadn't missed the funeral too. If you'd told anybody about that, maybe we could have moved it. But because you were supposed to be at a funeral and you're not, it doesn't make sense why that would make you late to this. In fact, I'd want to be in early to this so we could get it done as soon as possible, and I might be able to make part of that funeral. So look, I just want you to know this. You need to be able to be where you need to be when you need to be, or you're just gonna look. Some people belong in prison. Some people make the courts send them to prison because they just can't do the things they need to do. I don't want you to be that guy. So you know, you need to get it straightened out here. All right. For the sole count of conviction, that being possession of methamphetamine, criminal severity level 5 drug felony, criminal history E, the defendant will be sentenced to the mitigated term of 18 months. If he has to do that time, he'll be eligible for 20% good time credit and subject to 12 months of post-release supervision. His application for probation is considered and it is granted to community corrections for a period of 12 months. A specific term of that probation will be that he get a substance abuse evaluation and follow all the recommendations thereof. By operation of law, this sentence is required to run consecutively to that in 2016 CR 1009, given that this crime was committed while he was on probation for that one, and the court so orders. Mr. Tolefree, tell me this: what are you doing to make ends meet these days?
Like I told my lawyer the other day when he called me, he told me, "Hey, court, I've been working. I just got a job. But since I've been coming to court and all this stuff, I don't know how it's going to be working out because I've been missing days. So I'm gonna have to probably find
Right.
another job."
Well, it is certainly within your power from this day forward not to have any more court dates. You just need to do what you need to do on probation, and you can keep that job. Where are you working?
I was working well on M Road, this place called Intelligence Learning Center.
Okay. All
All
right.
schools, the schools equipment and stuff.
All right. Well, here's the deal. I'm going to order that you pay court costs. You're certainly able to keep a job and the supervision fee. Mr. Crawford, do you know what your attorney fees are?
No, I don't have it collected somewhere around $1,000.
All right. I'm only going to assess 100 of that versus the defendant and the bids fee as well. He doesn't have to pay the database fee because he's already in it. There's no mandatory fines. So that would be it. Court costs, supervision
Supervision
fee.
fee.
Pardon?
Supervision fee, Your Honor.
That's what I said.
Okay.
Court costs, supervision fee, bids fee, and $100 of Mr. Crawford's attorney fees will be all of the costs. Mr. Tolefree, I want you to be able to pay this off by the time of your probation, so it doesn't extend it at all. I'm looking at 2, 3, 4, 5, between $500 and $600. So if I order you to pay $50 a month, you'll be paid off before your probation ends. Do you believe that that's something that you can do?
Yes.
All right, that will be the court's order as far as that goes. All right, so wrapping up this sentencing part, you have 14 days from today to appeal anything you don't like about your sentence. You may be able to seek expungement of this conviction after successful completion of supervision. As a convicted felon, it's prohibited for you to own or possess a firearm. And certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. You understand all that?
Yes, sir.
Okay. So I think that wraps up our sentencing and we can move to the revo. Mr. Schneider, anything you think I've failed to cover?
No, Your Honor.
And Mr. Crawford?
No, sir.
All right. My understanding on the revo, now turning our attention to 2016 CR 1009, is that the defendant would stipulate that he has a new conviction and that the parties are recommending to the court that I revoke and reinstate his probation, extend it for a year today so that it runs along with this one. Is my understanding of all that correct as far as you're concerned, Mr. Schneider
Yes, Judge.
and Mr. Crawford?
Yes, sir.
All right. So, Mr. Tolefree, I think you'd have to agree that you did catch a new case while this old probation. Is that correct?
Yes, sir.
All right. This is what I'm going to do. I'm going to revoke your probation and reinstate it today. It will be extended for 1 year from today, which means you're not going to have to do any extra time. Your probations, regardless of how the underlying sentences run concurrently or at the same time. So you do this 12 months and you do it right, you'll be done with both cases, okay? But if you don't, you're going to have to do the 16 time and then the 2020 time. Is that clear?
Yes, sir.
All right, let's get it done. Other things for our record today?
Nothing by the state judge.
All right, then we will be adjourned. Good luck. Mr. Crawford,
Kevin.
I'm going to stop the stream here so I can give a phone